Geraldine Ssali Busula, Permanent Secretary, Minister of Trade and Industry. Legislators Michael Mawanda, Paula Kamba, Wamukuya Ignatius Mudemi, Kiria Julius Taita Nkoko, Advocate Kavundla Leonard, the Principal Cooperative Officer, Minister of Trade and Industry, have appeared at the Anti-Corruption Court for the charges against them. Before Magistrate Joani Asiro, court first granted prosecution prayers to amend the charge sheet by adding Geraldine Ssali Busula and to add alternative counts against the legislators.
Does not prejudice the accused persons. Further, prosecution also made a submission to the partially heard bail application to the effect that the same had been overtaken by events, to wit, the amendment. Grounds of objection. The application to amend and tender in the amended charge sheet was objected to by the defense on the following grounds. 1, that section 132, subsection 1A, is not applicable and cannot be invoked by the prosecution to cause an amendment. 2, that the amendment is not supposed to deprive the accused of their right to apply for bail free. The amendment is prejudicial to the accused now before this court. Issues and their resolution. Issue 1, whether section 132 subsection 1A is applicable and can be invoked by the prosecution to cause an amendment in the matter now before this court. Section 132 subsection 1A of the Magistrates Court Act provides that where at any stage of a trial it appears to a magistrate's court that the evidence discloses an offense other than the offense with which the accused is charged, then the court, if it is satisfied that no injustice to the accused will be caused, thereby may make such order for the alteration of the charge by way of its amendment or by the substitution or addition of a new charge as it thinks necessary to meet the circumstances of the case. The reasons for the objection by the defense is clear on record, and the response to the same by the prosecution is also quite clear on record. Upon a reading of the above section and giving it its literal meaning, this court finds that this section of the Magistrates Court Act cannot be invoked at this stage to cause an amendment. The section presupposes that there is some evidence laid before the magistrate upon which the magistrate can then, if satisfied that no injustice to the accused will be caused, order for the alteration of the charge by its amendment. In the matter now before this court, there is no evidence laid. With all the above, I do agree with the defense that section 132 subsection 1A of the Magistrates Court Act is inapplicable at this stage of this matter and cannot be invoked by the prosecution to cause an amendment. The objection raised in this regard is sustained. Issue 2, whether the amendment deprives the accused persons of their right to apply for bail. The objection giving rise to the above issue was based on the submission by the prosecution that the application for bail had been overtaken by events, the events being the amendment that introduces the offense of money laundering, which offense this court lacks jurisdiction to try, let alone entertain a bail application. The defense argument was basically that this amendment was meant to prevent the accused persons from enjoying their right to apply for bail, to curtail their freedom to personal liberty, and keep them incarcerated. But the prosecution submitted to the contrary. Indeed, as emphasized by the defense, the accused persons have the right to apply for bail as enshrined in Article 23(6)(a), Yes, 23(6)(a) of the Constitution of the Republic of Uganda. This is the position and an amendment that introduces an offense. This is the position and an amendment that introduces an offense that the court lacks jurisdiction to entertain does not take away the right of the accused person to apply for bail. It would only mean that the accused persons cannot apply for bail before the court that lacks the jurisdiction to entertain the introduced offense, but exercise their right to apply for bail before the High Court, clothed with the jurisdiction to try the offense, and in this matter, the High Court, that is the Anti-Corruption Division. In other words, the amendment, if allowed, does not do away with the accused's right to apply for bail before a competent court. This objection is thus overruled. Under this ground of objection was also an argument put forth by the defense basing on a constitutional appeal number 3 of 2009 Foundation for Human Rights Initiative versus Attorney General, in which court stated basically that a court which has powers to try an offense also has powers to grant bail in respect of that offense. According to the defense, this court should go ahead and entertain the bail application for the accused persons who are charged with the offenses that are within its jurisdiction, and let the High Court entertain that for which this court lacks jurisdiction. Or in the alternative, this court orders that the accused charged with money laundering be charged on a separate charge sheet. The rationale for this definitely being that this court can then go ahead to entertain bail application for the accused whose charges are within its jurisdiction. I must agree with the defense on their submission that if a court has jurisdiction to try an offense, then such a court should have powers to hear a bail application in respect of that offense. But that notwithstanding, I find that the case now before this court has a different circumstance from that cited above by the defense. The circumstance of the matter before this court now is that an offense for which it lacks jurisdiction is being sought to be added through an amendment. The circumstance now before this court is in tandem with the case cited by the prosecution, to wit, High Court Criminal Division, Criminal Revision, case number 1 of 2024, arising from Nakawa Criminal Case number 43 of 2023, Uganda versus Katanga Moli and 4 others, where court stated that where a charge sheet has a capital offense only triable by the High Court, the Magistrates Court ceases to have locus to entertain the bail application. That is to say, even if there are other offenses or offense with which the court has such locus, the court cannot entertain any bail application. Therefore, this court, if the amendment is allowed, cannot entertain any bail application in respect of any of the accused persons. With this, for reasons given by the defense, to order for the separate charge sheets for the 2 categories of the accused persons, simply for this court to clothe itself with gun. According to the defense, the introduction of money laundering in the charge sheet cannot be used to prejudice the accused persons, and the same is also simply an abuse of court process. That the prosecution's position that the accused this application for bail is overtaken by events all amounts to abuse of process. To fortify its position, the defense relied on the case of Malema Birizi Chiwanuka versus Attorney General, miscellaneous application number 917 of 2021. That was in Civil Division, which case I also find very inappropriate to be applied to the matter now before this court. The prejudice claimed is that then the accused persons cannot apply for bail before this court, which position I find does not amount to any prejudice to the accused persons if the amendment is allowed. As already mentioned earlier, the accused persons then get to exercise their right or make their bail application before the High Court. With all the above, the third objection is also overruled. There is no prejudice to the accused persons that would be caused in regard to their right to apply for bail. Also having in mind that the same has no link with the fair trial of the accused persons or with evidence yet to be adduced. All said above, court is alert to the fact that the Director of Public Prosecutions has the right to amend a charge sheet at any stage of the proceedings, and the only test is whether the amendment is prejudicial to the accused persons or if it causes any miscarriage of justice or if it is an abuse of court process. The current amendment is not prejudicial to the accused persons. I do not see any miscarriage of justice that will be caused to the accused persons. Neither do I see any abuse of court process. The amendment is thus allowed, and the charge sheet may be tendered in court so that the charges can be communicated to the accused persons, S6 inclusive. The bail application that had earlier begun definitely is now overtaken by events.
We are praying for you.